I'd like to welcome everyone this morning. Chairman Westerfield is going to be away for the first part of the meeting, and I will be handling the chair until he arrives. I'd like to welcome everyone to the 10th meeting of the 2022 General Session of the Committee on Judiciary, and would ask the clerk please call the roll.
Senator Berg. Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler. Senator Carroll.
Here.
Chairman Westerfield.
We do have a quorum. Before we begin, I'd like to welcome a group that is here from the Hopkinsville Christian County Chamber of Commerce and also Leadership Hopkinsville. Could you all, the folks, please stand? Yeah. And I think Chairman Westerfield said something about paying for all of your dinners tonight at Serafini's. So when you talk to him, you should mention that. Welcome, and appreciate you all making the trip up here. We have a very long agenda today, so we're going to jump right into it. First on the agenda, we will ask Senator Denise Harper Angel to come to the table. Senate Bill 378, and this is an act relating to Crimes Victims Compensation Board. Senator Angel, Harper Angel, welcome. Please introduce yourself and your guests for the record, and you have the floor, ma'am.
Good morning. Thank you, Mr. Chairman and members of the committee. I'm Denise Harper Angel, Senator for the 35th District. I'd like my guest to introduce herself for the record.
Yeah, good morning. Layla Cauchon, staff attorney with the Kentucky Association of Sexual Assault Programs.
Mr. Chairman, I appreciate the opportunity. I know you have a lengthy agenda, so I will be brief. Senate Bill 378 ensures that members of the Crime Victims Compensation Board and their staff receive trauma-informed training to better understand the challenges faced by victims of crime. The training will consist of 6 hours within 30 days of being hired and 3 hours each year thereafter with agencies that specialize in victim advocacy. The executive director of the Claims and Appeals shall keep written records documenting the completion of the training. And every professional who interacts with victims of crime should have a basic understanding of the impacts of crime on victims to ensure best possible outcomes. Training is an essential component, and Senate Bill 378 is a great step forward. Now I'll turn to my guest for brief remarks about how she believes 378 is needed.
Great. Thank you, Senator Harper Angel and members of the committee, as well as I want to give a shout out to the co-sponsors, Senator Neal, Senator Westerfield, and Senator Rocky Adams. And we are here to support Senate Bill 378. KSAP, that's what we call ourselves for short. We're the Coalition for the State's Rape Crisis Centers, and our centers provide support to individuals who've been sexually assaulted or abused. They do that in a few ways. They provide therapy, counseling, education. They can accompany them to legal and hospital needs that they have, and much more. So as the coalition, we are familiar with crime victims compensation, and our local program advocates work with victims in going through that process. And that also means that we hear about the barriers, the denials or recommended denials of claims, victim blaming, and more that some individuals have experienced going through the process. We know that, the knowledge of a crime victims compensation member who reviews the claim should not be one of those barriers. We understand that while the Crime Victims Compensation Board does its best within what the statute requires, Senate Bill 378 addresses the training gap. Victims depend on Crime Victims Compensation Board to understand their claims, including a possible delay in filing a claim. In current statutory language, the board can make certain exceptions, but without Senate Bill 378, members may not fully understand why or when exceptions would be appropriate. Crime Victims Compensation Board has done a good job recently in providing trainings for professional groups and organizations about what they do, and now is the time to ensure that they also receive the best training for their own members. While crime victims compensation cannot make a victim whole again, Senate Bill 378 can help ensure that all steps are taken to provide victims with those best possible outcomes in their claims. And we agree with Senator Harper Angel that this is a great first step. So thank you, and we're happy to take any questions.
Motion.
We have a motion by Senator Schickel, a second by Senator Wheeler. Clerk, please call the roll.
Senator Berg. Senator Carroll. Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler.
Aye.
Chairman Westerfield.
Bill passes, a vote of 6-0, and favorable expression will move to the floor.
Second.
Have a motion for consent and a second. All those in favor, please signify by saying aye. Opposed, no. Motion carries. Bill will be carried on the consent agenda. Senator Denise Harper Angel, congratulations, and looking forward to that bill moving forward. Appreciate your work on that.
Thank you, Mr. Chairman, and members of the committee, and everybody have a happy St. Patty's Day.
Thank you.
Okay, next on the agenda, we will move to House Bill 256, Representative Daniel Elliott, an act related to the unauthorized practice of. Representative Elliott, please introduce yourself for the record, and you have the floor, sir.
Thank you, Mr. Chairman, members of the committee. Daniel Elliott, State Representative for the 54th District, Boyle and Casey counties. Mr. Chairman, House Bill 256 is an act related to the unauthorized practice of law. It would move a first offense from a Class B misdemeanor to a Class A misdemeanor, and it would create a new class of crime for a second or subsequent offense, and that would be a Class D felony. And I know you have a busy agenda, so I'll take any questions at this time, Mr. Chairman.
Have a motion by Senator Schickel, second Senator Berg. Clerk, please call the roll.
Senator Berg. Senator Carroll.
Aye.
Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler. Chairman Westerfield.
Bill passes with favorable expression. Okay, we have two members that just. Okay, we're going to have a brief recess. I think we have two members that just walked in that would like to cast their vote.
Senator West.
I'd like to explain my vote. I vote aye, and I apologize to the committee. I was in another meeting and could just attend, but I vote aye. Thank you.
Senator Schroeder.
Thank you, Mr. Chair. Apologize. I was meeting with leadership. Actually, because I missed testimony, I think I'm going to pass on this one.
It's at 6-1 and 1, Mr. Clerk. Okay. Bill does pass now with favorable expression by a vote 6-1 to 1, and we'll move to the Senate floor. Senator Elliott, or Representative Elliott, I'm sorry. Thank you, sir.
Thank you, Mr.
Congratulations.
Chairman, members of the committee.
Okay, I think at this point we will move to Senate Bill 245. This is an act related to protective orders. Senator Johnny Turner. Please move to the table, Senator Turner. While we are waiting, I think Senator West would like to record a vote.
Thank you, Mr. Chairman. I was absent and wish to be shown as voting aye on Senate Bill 378.
Senator Turner, please introduce yourself for the record, and you have the floor, sir.
Thank you, Mr. Chairman. I'm Johnny Turner, Senator for the 29th District. And I have today a bill which is commonly referred to affecting and having some impact on EPOs. A little history, prior to the EPOs being put in statute in 1992, a aggrieved party in a domestic relation thing had to file a petition for a temporary restraining order, which required retaining a lawyer and going through a process, going to a circuit judge. In 92, when the section of statutes was introduced, 403-740, and then later on we got 456, which comes into play in my bill also. The 403, if you want to look at the papers in front of you, I would go from 740 to 730. 730 is when a person who is aggrieved goes in before a district judge and files with the clerk a petition for protective order. Present statute does not allow for anything for the judge to do except basically sign the petition, issue it, and that has been in effect since 1992. Under the amendments that I have filed with these in these two provisions, and they're the same in the 730 and the 456, it allows the judge upon the filing of the petition, present statute says upon proper motion. Under this amendment, it's just upon the filing of the petition. The judge can do the same things that's already in the statute, but this amendment allows the judge to allow the parties to have some communication if requested by the petitioner, the person that is aggrieved, and the communication which is unauthorized. The purpose of that is most of these parties have children, they have sickness, they go to school, and there needs to be communication. So that is the purpose of that section of the amendment. This paragraph 3 of that amendment allows either party, because sometimes if the wife is the one who takes the petition and she's living in a residence that belongs to somebody else or whatever, she may be the one that has to move. This allows either party to retrieve their personal belongings from the party's shared residence with the directing law enforcement officer that normally goes and serves the petition to assist. A protective provision in this statute also says nothing in this paragraph shall be interpreted to place any restrictions on the restraint of the petitioner. That purpose is because federal law prohibits you from restraining the party that files the petition initially. Now, if you go back then to the 730 is when the petition is originally filed. 740 does the same provisions,
Mr.
but
Chair, I would make a motion on the sub first.
Second.
Okay, we have a motion and a second on the sub. All those in favor of passing the sub, please signify by saying aye.
Aye.
Opposed, no.
Mr. Chair, at this time, I would make a motion on the underlying, the bill as amended by the adopted sub.
We have a motion on Senate Bill 245 as amended by Senate Committee Substitute 1. And that was
Senator Schroeder.
Senator Schroeder, and a second by Senator Wheeler. Clerk, please call the roll.
Senator Berg. Senator Carroll. Senator Kerr. Senator Neal. Senator Schickel.
Aye, and I'd like to explain.
Please proceed.
Thank you. I want to thank the bill sponsor. The senator has a lot of experience over the years, and this is an area where I get some feedback from my constituents, and he's talked to me about it, and I've read over, and I think it's a very good improvement. Thank you, Senator.
Senator Schroeder.
Aye.
President Stivers. Senator Turner.
Aye.
Senator West. Senator Wheeler.
Mr. Chairman, explain my aye vote.
Please proceed.
This is good common sense legislation. I'm proud to be a co-sponsor of it, and I want to thank the senator from Harlem for bringing this bill.
Chairman Westerfield.
Very good. A vote 8-0. Have a motion for consent. All those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Bill will carry forward to the floor on the consent agenda. Congratulations, Senator Turner.
Thank you, Mr. Chairman. I apologize for failing to move to get the sub.
Okay, I do not see Representative Meredith here. Am I missing? Is he here? Okay. Representative Meredith, please come to the table. We have House Bill 590, which is an act relating to jails. Please identify yourself for the record, Representative, and you have the floor, sir. And your guest.
Thank you, Mr. Chairman, members of the committee. Michael Meredith, representing the 19th House District, and I have with me Jim Daly, the president of the Kentucky Jailers Association today. House Bill 590 is a fairly simple piece of legislation that really just makes sure we continue doing the same thing that we have really been doing over the years. There was a court case in October of last year that created kind of a burden in the process of charging back inmate fees to the inmate through their commissary accounts.
We have a motion. Is there a second? Second by Senator Schroeder. Do we have any questions on this? Senator Neal.
So if someone is in jail and they are later acquitted, they still would be chargeable under this?
No, there is a provision in this bill that creates a reimbursement system for somebody who is acquitted after their housing in the jail.
Thank you very much.
Any other questions? Senator Schickel.
Jailer Daly, it's great to see you, president of the Jailer Association, the pride of Northern Kentucky. I think this would be an interesting statistic for some of the members to know the percentage of collection on these fees, because I understand it's very low.
Senator, it is very low and has been forever. We do get some on the initial intake, but generally after that, the inmates know how to work the system pretty well, so it drops off tremendously at that point.
Any other questions? Clerk, please call the roll.
Senator Berg. Senator Carroll. Senator Kerr. Senator Neal.
I'd like to explain my past vote.
Please proceed.
Yeah, my concern is that normally who we have in jails are people that are already challenged by funds and so forth. They're already pressed to the wall, and I'm ambivalent about that. That gives me really great concern. Doesn't mean I might not support it on the floor, but I want to give some more thought to it.
Senator Schickel.
Aye.
Senator Schroeder.
Aye.
President Stivers. Senator Turner. Senator West. Senator Wheeler,
Aye.
Chairman Westerfield.
Okay, on a vote of 6 aye votes, 2 pass votes, the bill passes with favorable expression and will move to the floor. Representative, congratulations.
Thank you, Mr. Chairman, members of the committee. Appreciate it very much.
Mr. Chair,
Yes, sir.
so that wouldn't be eligible for consent because of the pass?
Not with the pass votes.
Okay, thank you.
Chairman Massey, you want to come to the table, sir? Let's, if you're okay, is there any preference on your 3 bills?
None whatsoever.
Okay, we'll start with House Bill 310. This is an act relating to home incarceration. You have the floor, sir. Please introduce yourself for the record.
Thank you, Mr. Chair, members of the committee. My name is Ed Massey. I'm a representative from District 66 in Boone County. This matter relating to home incarceration is very simple. Judges have the ability to give home incarceration as a release. They can do it either monitored or unmonitored. It's their discretion, their choice. What's happened in some cases is people started out perhaps maybe unmonitored, and then later, because of COVID, there was a lot of issues about keeping people incarcerated, and later on then they were monitored. But judges, in their discretion, have given credit for the time they were monitored, but weren't giving credit for the time somebody wasn't monitored. So in fairness and justice, if somebody is going to be restricted of their liberties and be incarcerated at home, not free to go where they want.
We have a motion by Senator Wheeler, a second by Senator Neal. Any questions?
Question.
Senator Schickel.
Good to see you. Another pride of Northern Kentucky here. Good to see you, Representative. Explain to me, I read over the bill, the summary of the bill. Explain to me going forward. So if someone is unmonitored on home incarceration, they will get credit just as if they're in jail pre-trial.
That is correct.
Thank you.
Any other questions? Clerk, please call the roll.
Senator Berg, Senator Carroll,
Aye.
Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder,
Mr. Chair, explain my vote.
Please proceed.
Thank you. I vote no today. Sorry, Representative. I want to double check with my judges. This isn't something that I support right now. I want to check with my judges. I'll talk to you again, make sure I'm not missing something. But for today, I vote no.
President Stovers, Senator Turner, Senator West, Senator Wheeler,
Aye.
Chairman Westerfield.
Okay, on a vote of 7-1, the bill passes with favorable expression and shall be moved to the floor for consideration. Okay, Mr. Chairman, let's move to House Bill 458.
Thank you, Chairman. House Bill 458 is a very, very simple bill. There is what's called a DJJ, Department of Juvenile Justice Oversight Committee. It's going to expire in May. This simply keeps it going. That's what it does.
We have a motion, Senator Neal, second by Senator Wheeler. Any questions? Clerk, please call the roll.
Senator Berg, Senator Carroll, Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder, President Stovers, Senator Turner, Senator West, Senator Wheeler, Chairman Westerfield.
The bill passes on a vote of 8-0. I have a motion for consent by Senator Neal, second by Senator Schickel. All those in favor, please signify by saying aye. Aye. Opposed, no. Bill moves on with favorable expression to the consent agenda. Mr. Chairman, your final bill, House Bill 501, an act related to child support. Please proceed, sir.
Thank you, Mr. Chairman. This one's not a complicated matter, but it was difficult to put into statute. So last year, we upgraded our child support guidelines, which had not been done in over 20 years. This is a companion to that because one of the things with shared parenting coming in as a preference in 2017, or as a basically underlying premise, meant that we had to give credit for overnight parenting time. So if somebody's paying support, it can be adjusted based on whether the person has shared custody. If it's 50-50, it's easy. But when you have somebody, because of work schedules, where one person may have them 3 nights a week, one person may have them 4 nights a week, then there has to be adjustments made on those calculations. We tried our best to put it in statute. We looked at the Oregon method, Arizona method, Kentucky method, Tennessee method, Michigan method. We came up with a Kentucky model. And we did put it in statute, and according to Craig Ross, which is the computer software company that does these schedules that lawyers follow for child support, it is a workable plan. But we want to create a situation that doesn't create complexity for the courts and doesn't increase the workload of judges or practitioners in trying to compute these formulations. So what we've done is we've delayed the onset of this in action until March 31st of 2023 with this idea in mind. We believe the statute certainly is workable. The Child Support Commission will be directed and will create a manual that will be used by the courts, used by practitioners in order to effectuate the outcome of this. In that time frame, we have also asked for the input from family law judges, from practitioners, and people that do this work so that we can make sure it's the most simple way to go about this. We're not trying to create work for anybody. It's just a very laborious process. I worked with a drafter on this for nearly a year, and I want to give a shout out to the 2 drafters, Lexington Sowers and Roberta Kaiser. They have worked on this, and they put it into a form that's workable, but it's hard for the general public to understand, hence the need for the child support manual that will be created by the Child Support Commission, and hence the need to delay the onset. This passed unanimously out of our committee and Judiciary, passed unanimously.
Okay, we have a motion by Senator Wheeler, a second by Senator Neal. Senator West, you have a question, sir?
Thank you, Mr. Chairman. To be clear, the new manual and the new guidelines will allow credit for that time specifically. Is that correct?
That is correct. It's a sliding scale depending on the overnights, and it also defines what an overnight really is. Because just spending the night at somebody's home from 11 p.m. to 6 a.m. may or may not constitute an overnight depending on the circumstance.
Thank you.
Any other questions? Our Senator Byrd.
Thank you. Just a quick question, having been through this most of my life. The judge decides, okay, the kid's going to spend 3 nights here, 4 nights here. We're going to redo this based on that allocation. And then one of the parents just doesn't show up. Do you have to go back to court to reallocate this whole distribution because one of the parents isn't showing up after school and picking up the kid and keeping him overnight?
Not necessarily. First of all, in that particular scenario that you gave, it would probably be a motion for contempt because somebody was not following the court order. But if somebody's work schedule changes, then the parties would first try to come to an agreement based on the formula about what the arrangement should be, and only thereafter would they go back to court. We're trying to keep people out of court, which is why we're trying to make it as simple as possible, hence the manual.
Seeing no other questions, clerk, please call the roll.
Senator Berg. Aye. Senator Carroll. Aye. Senator Kerr. Senator Neal. Aye. Senator Schickel. Senator Schroeder.
Aye.
President Stivers. Senator Turner. Aye. Senator West.
I'd like to explain my vote.
Please proceed.
I vote aye, and I just want to thank the sponsor for your work on this. I'm a real estate lawyer, and there's a reason for that. You get into family law, it gets really, really crazy. And anytime you touch these child support guidelines, I know how much work was involved. And we get into this committee and we just talk about it for 5 minutes and move on. But I just want to thank you for your hard work and the work of staff. And I know how much work's involved when you touch these things. So thank you.
Senator Wheeler.
I want to echo the comments from my friend, the senator from Bourbon. Ed, thank you for your hard work on this. And your dedication to these causes are very, very noble and praiseworthy. So thank you.
I think the mic was on, just it wasn't working very.
Chairman Westerfield.
Okay. On a vote of 8-0, passes with favorable expression. We'll move to the floor.
Motion
Do
for
we have a
consent.
motion for consent?
Second.
Who made the motion?
Not sure.
Senator Wheeler. Second, Senator Turner. All those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Bill will be moving to the consent agenda. Mr. Chairman, thank you so much for your attendance and presentation of your bills today. Congratulations, sir.
Thank you, members and chairman, and have a great day.
Okay, we're going to move up to House Bill 222. Representative Kulkarni, and this act related to legal actions concerning the exercise of a person's constitutional rights. And I think Representative Nemes will also. There they are. Welcome, lady and gentlemen. Please introduce yourself for the record and introduce your guest, Representative Kulkarni, and you have the floor, ma'am.
Thank you, Chairman. I'm State Representative Nima Kulkarni. I represent District 40, and I'm joined by my colleagues here.
Jason Nemes, I'm sorry, go ahead.
No, you go ahead, Jason.
Jason Nemes represent House District 33, that's Jefferson, Oldham, and Shelby counties.
John McGarvey, I am your legislative liaison with the Uniform Law Commission.
Please proceed, ma'am.
And I'm so sorry, we have two guests on Zoom. I don't know if we need to have them introduce themselves.
Yeah,
as well.
let's do. Are both of these folks here?
I can introduce them, Mr. Chairman. We have Caitlin Wolf, who is counsel of the Uniform Law Commission and our subject area expertise on this bill, and Mr. James Bopp Jr., a lawyer from Terre Haute, Indiana, who is one of the drafters of the Uniform Act that's being presented.
Very good. Please proceed, ma'am.
Thank you, Chairman and members of the committee, for considering House Bill 222 this morning. At its core, this bill safeguards First Amendment rights in our courts and makes sure that everyone gets a fair and expeditious day in court. Specifically, the legislation creates a procedure by which a judge may dismiss certain civil lawsuits that are used strategically to intimidate, censor, or silence those who speak out on a matter of public interest or concern by burdening them with the cost of a legal defense against a meritless lawsuit. These are known as SLAPP suits, or strategic lawsuits against public participation. This phrase was coined in the early 70s, and since then, over the years, there have been several states that have enacted their own anti-SLAPP statutes. Now, some of these state statutes have been problematic because they differ greatly in terms of scope and applicability, which is why the Uniform Law Commission chose to develop a uniform law over the course of 3 years with input from numerous stakeholders. The Uniform Public Expression Protection Act was adopted in 2020, and this legislation is based on that act. This bill has been modified and strengthened quite a bit since I first introduced a version back in 2019, with a lot of input and feedback from even more stakeholders. It has been modified to address every concern that was brought to our attention, ensure that it is not at odds with any aspect of our civil procedure, and still stay within the realm of uniformity for ULC purposes. It has broad bipartisan support. It is endorsed by organizations across the ideological spectrum, including the ACLU, Americans for Prosperity, the Bluegrass Institute, the Kentucky Open Government Coalition, Kentucky Press Association, the Pegasus Institute, Public Participation Project, and the Uniform Law Commission.
Please continue. I think we're going to continue on with the testimony.
Okay, thank you, Chairman. This legislation passed unanimously out of House Judiciary Committee and on the House floor. It's been vetted and combed through for the past 3 years by numerous legal practitioners, and it is narrowly tailored to achieve its intended purpose. It has such broad bipartisan support because it makes our judicial process less cumbersome and more fair. And with that, I'm happy to answer any questions, Chairman and committee members. Otherwise, I'll turn it over briefly now to Mr. McGarvey and Mr. Bopp for their comments.
Just briefly, the Uniform Law Commission studied this issue for a year and identified the various sub-issues that needed to be considered. They then launched a drafting committee which worked on it for a year, presented it to the full commission, worked on it again, presented it to the full commission, and tweaked it, and was offered to the states in 2020. Ms. Wolf is available to answer questions. Mr. Bopp, who's a preeminent constitutional lawyer and with unassailable conservative credentials, will just give you a couple of minutes. I've explained to him your time constraints explanation of the act.
Very good.
Thank you very much.
Please proceed, sir.
Thank you very much, Mr. Chairman, and I'm pleased to testify in favor of House Bill 222, Kentucky's Anti-SLAPP Act. I am a Uniform Law Commissioner from Indiana, and I was on the Uniform Law Commission Drafting Committee that drafted the ULC Anti-SLAPP Act. I enthusiastically endorse House Bill 222, which is based on the Uniform Law Commission model. There is broad bipartisan support for anti-SLAPP acts, and both liberals and conservatives agree that it is necessary and vital protection to the First Amendment. Now, I come at this from the conservative Republican perspective. I have represented nearly every major conservative group in the United States at one time or another over my 49-year career, and I have been very active in the Republican Party, rising to vice chairman of the Republican National Committee and representing them as counsel in the United States Supreme Court, winning a First Amendment case. This act prevents wealthy individuals from attacking groups or individuals from engaging in free speech by frivolous and meritless lawsuits, by requiring them to show that they have a case with merit early on. As we all know, government cannot suppress free speech, and I view these cases as using government, i.e. the courts, to do that very thing. And I know from my own career how important anti-SLAPP laws are. I have already won nearly a half dozen anti-SLAPP cases throughout the United States on behalf of conservative groups. Anti-SLAPP motions are a vital defense of the First Amendment, and I urge you to adopt it. House Bill 222.
Thank you, sir. Any closing comments, Representative Kulkarni?
I'm happy to entertain any questions from members.
Very good. We have one from Senator Neal.
Thank you, Representative Kulkarni. Thank you, Mr. Chairman. Basically, what this does, it doesn't compromise any constitutional rights of those who would bring a lawsuit, but it sort of expedites it. It moves it forward by requiring a showing of a substantive claim as opposed to going down the process and having the system exploited by conservatives and liberals. I don't see what conservative or liberal has anything to do with this, quite frankly. It just seems like it's a good, solid piece. I just wanted to say to Representative Nemeth, this looks like a good piece of legislation here.
Senator Neal, I knew my audience is why we have Mr. Bopp here this morning.
Yes, Senator Neal, that's correct. This does not change the ability of anybody to bring a lawsuit. It doesn't change any of the rules of our current civil procedure. What it does is provide a framework for an expedited motion to dismiss, essentially, and a framework within which a judge can analyze whether or not a suit is being brought for delay purposes or to intimidate or censor any speech.
All right, thank you.
Senator West.
Thank you, Mr. Chairman. My question, and anybody's welcome to answer this question, but my question is in reference to page 7, line 12. It deals with the costs and expenses. Is this like a loser pays type situation? And and first let me say I'm not against that in this case. I think that's the cost of losing in this particular case. Is that kind of, I mean, the loser in that case, if it is the public entity, would have to pay court costs and all the items here in section.
Senator, let me say first off, I don't know if I'm in the minority here or not. I'm against loser pays. I'm against tort reform. I'm against loser pay, and that's a form of tort reform. This situation is not that. We have areas in our law. The English system is loser pay. The American system is not, obviously. But we do have areas in our law, whether it's by contract or some places like 1983 claims, where one can get fees under 1988, where we do allow the prevailing party whose constitutional rights have been violated to prevail. In this case, it's more akin to that. Why? Well, because this is something that someone has proven that they have been sued for a frivolous or a unacceptable reason. They have to make a motion. They have to make that showing, and once they make that high showing, then and only then are they entitled to have their costs paid by the party who has inappropriately brought the lawsuit. So I wouldn't put it in the context of the normal loser pays as we as attorneys think. I'd put it more in the context of this is to ensure the protection of the constitutional rights of the person who's been wronged and who's proven they've been wronged.
Thank you.
Senator Schroeder.
Thank you, Mr. Chair. I want to ask about an example. One of the parties in support of this legislation sent out basically a one-pager in support of it. Gave an example, and it just kind of, I thought I understood it, this legislation, but now this is kind of causing me some questions. So it says a restaurant owners threatening defamation suits against customers who leave negative reviews on a website. I guess could you explain, give me a fact pattern maybe to help me out?
So I think that's a very specific example. The applicability of the statute has to do with anything that is of public concern or public interest that would be covered by the First Amendment, right to free expression. So I think what that example was, and this was, I think, a Yelp review that was left by somebody where the restaurant owner then tried to sue for defamation, so which is a commonly used suit that would be brought for these purposes. But it could be applicable in a lot of different ways. I don't know if you want some more specific examples.
So I guess extending this example out, restaurant owner, I'm a restaurant, you leave a bad review, and then you try to say under this, I shouldn't be able to bring a defamation case. Is the judge is looking to see if my defamation claim has any validity and then is making a decision?
Yes, so in any example that you want to think of, the judge would use this framework to analyze the lawsuit and say, is this being brought, does it have any merit, right? So it's just, does it meet the basic requirements? And you're not going through sort of the whole discovery process or anything to get to the end of the defamation lawsuit. It's an expedited review, basically. So if the judge does determine that it is frivolous and it has been brought to suppress speech of any kind, then they can use this statute to expedite the dismissal of that particular motion.
Okay, and then is there an appeal if the restaurant owner feels?
Yes.
Who's the appeal to? I'm just curious.
It would be in Kentucky, it would be the Kentucky Court of Appeals.
Oh, I just wanted to make sure there wasn't some kind of exception under this lawsuit
No.
or something like that. Okay.
I assume, Senator, there could conceivably it could be to the circuit court if the action was filed in district court, but that's highly unlikely.
Okay, thank you.
Senator Wheeler, you have a question, sir?
Thank you, Mr. Chairman. And I hate to get into esoteric law school discussions, but just oh, sorry. Oh, that one's not. There we go. Guess I'm not holding it close enough. And hypothetically, and if you had a situation, say, as a politician, normally we have a higher standard on defamation. Paper under New York Times versus Sullivan can print something bad about us, and unless we show actual malice, we can't collect. Let's just say I happen to question the constitutional validity of that case because, constitutional precedent does change through the years, and I sue a reporter, and they make a motion to dismiss under New York Times versus Sullivan saying this is inadvertent, didn't mean to, This is just brought to cost our newspaper money. Given that I have an actual, say, constitutional argument that I feel that the court was wrong in that case, and the Supreme Court does reverse itself, as we know, would this apply to me if I ended up losing that case? Would I have to pay costs? Would that be considered a slap action because I'm essentially going against the grain on constitutional precedent by filing this lawsuit?
I don't think so, Senator. In that situation, obviously you don't have the imbalance of power that this is designed to attack in the first place. I don't think you would be meeting the standards in Section 2(1) A, B, and C in order to have that situation occur where you would have to pay the press their legal fees. So I don't think the answer. I don't think the answer to that's yes. I don't know, John, if you can have a better.
Well, Representative Nemus and Senator Wheeler, I think Commissioner Bott may be able to respond to that.
Happy to. The lawsuit has to be, the plaintiff's lawsuit has to be premised on the exercise of First Amendment rights by the defendant. And if the defendant can demonstrate that that is the case, you then shift to the second part of the lawsuit, which is that the plaintiff has to then demonstrate that he or she has a prima facie case, or the defendant has to demonstrate that they would win on summary judgment. So, of course, if you have defamation claimed against a public figure, you do, one of the elements, as you mentioned, is of course malice, and so malice would be part of the factors that would have to be considered, and whether or not there's evidence of malice, for instance, under the prima facie showing, for the anti-SLAPP action to prevail.
Are you good, Senator?
Yeah, I'm good.
Okay. One final question, Senator West.
Thank you, Mr. Chairman. My questioning goes along the kind of the similar lines as Senator Schroeder, and I'm just trying. I know what it says on paper, but I'm trying to get an idea of implementation, what it looks like in the court. So currently, you can do a motion for summary judgment, and this would be kind of akin to a motion for summary judgment, except we're setting up these elements for the judge to consider. So is that how you envision this moving? Is it's an initial action filed really early? The judge makes this initial determination and makes an up or down decision, kind of similar to a summary judgment. Is that what we're doing?
Yes, and I'll defer to my co-sponsor, but yes, ultimately this just provides for an earlier analysis so that the cost of discovery and the cost of the full litigation does not stop the underlying First Amendment protected speech or action from proceeding.
And if the judge says no, then you would immediately go to Court of Appeals?
Well, if
you wanted to.
If there's an immediate appeal, obviously in Kentucky, we're very rare that you have an immediate right to appeal. Here's one of them. But I would say, yeah, I agree with everything that's been said, except for rather than a Rule 56, I think this is more akin to a Rule 12 motion because the discovery we wouldn't be along in this.
I agree with Senator Nemus, and you'd have to have that certification there was a final and appealable order.
Okay. Don't demote me. I'm Representative Nemus.
Oh, excuse me.
Sorry.
Last time I was
Chairman.
Senator West rose to chairman.
It's about a power balance here, you know. Yeah. Thank you.
Very good. We had a motion on the bill from Senator Schickel. Do I have a second? Second from Senator Westerfield. Clerk, please call the roll.
Senator Berg.
I would like to thank all members that brought this forward. It's obviously been a lot of work. I've been hearing about this for several years, and I'm just really, really glad we got to a point that we've got something that looks good and workable. Thank you very much.
Senator Carroll.
Vote aye, and I would like to compliment you all on the bipartisan effort. It's nice to see those things happen, so congratulations.
Senator Kerr. Senator Neal, Senator Schickel,
Aye.
Senator Schroeder,
Aye.
President Stivers, Senator Turner, Senator West, Senator Wheeler.
Mr. Chairman, explain my no vote.
Please proceed.
This is a tough one for me because these two representatives are two of my favorite people in the House. I mean, they really are, and I believe that their motive in bringing this is good. But you know, I've consistently been against loser pays, and you know, I think that although I know that Senator Nemus doesn't agree with loser pays in most circumstances, I think that this somewhat advances that argument, which I think limits access to the justice system. So I'm voting no for that reason.
Chairman Westerfield.
I vote aye.
On a vote to 8-1, motion, bill carries. With favorable expression, we'll move to the Senate floor. Congratulations, Representative Cole Carney.
Thank you, Chairman. Thank you, members.
And I will yield the floor to Chairman Westerfield. I would like to advise the folks from Christian County. I notified him of dinner plans, and the location has changed to McDonald's. Take care, everybody.
Yeah, thanks. I appreciate that. I was going to thank Vice Chairman Carroll for presiding over the committee, and I realize now what a grave, grave mistake I've made. Thank you, Chairman. I appreciate it. I appreciate your all's help while I was over in the Supreme Court chamber for oral argument over there. Our last bill on the agenda is House Bill 269. I know Leader, Whip, what's your position? State Rep. Representative Chad McCoy, an act relating to mental illness. Members, this is a bill we've seen before, and that has come out of our committee a couple different times and come out of the Senate a couple different times. I want to thank Representative McCoy for starting it over in the House, and welcome Ms. Sheila Schuster. Glad to have you here with us.
It's actually Sheila O'Donnell Schuster. That actually is my name, so.
Got it.
Thank you.
After all these years. Yeah. Thank you.
Thank you.
You have the floor.
Thank you, Mr. Chairman. Good morning, everyone. As the chairman said, this is a bill we passed out of this committee last year with a little modification. Senate President Stivers had some input on actually tightening the language here. What this bill does, it says that if a defendant has a serious mental illness, which I'll walk you through real quick, then the death penalty is off the table for them. Doesn't mean they're going free, doesn't mean they're not getting punished. It just means it's going to be life in prison without parole rather than actual death penalty. So what is a defendant with a serious mental illness? Well, it's someone who, at the time of the offense, has active symptoms of a documented history that was documented and diagnosed by a mental health professional, as already defined in statute. So if you meet those criteria and you have one of the 4 listed diagnoses, then you are a defendant with serious mental illness and the death penalty is off the table. Happy to answer any questions.
Got a motion from Senator Neal. I'll make the second. Any questions? Did you make the second? Senator Wheeler, we'll show him then. Senator Carroll.
Thank you, Representative and Sheila. In the past years when we've had this bill, my concern has always been the state of mind at the time the crime occurs. And so I think you all have addressed that in that when it comes down to it, it will be what was occurring at the time the crime occurred, the manic state, other symptoms of that mental illness would have to be present during the time of the crime to fall under this, correct?
That is correct, sir, yes.
Very good. Thank you. Thank you, Mr. Chairman.
Any other questions? Seeing none, we have a motion and a second on the bill. Mr. Secretary, please call the roll.
Senator Berg.
Aye, and again, this is one of the recommendations that came out of our Severe Mental Illness Task Force, and I really want to say thank you very much.
Thank you.
Senator Carroll.
I'd like to vote aye and explain my vote.
Yes, sir.
thank you all for the changes and continuing to work on this. And, I think now I don't know how you can not be comfortable with this. So I appreciate your efforts, and I'm glad to finally be able to vote aye for this.
Thank you.
Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder.
Mr. Chair, explain my vote.
Yes, sir.
I vote aye as well. Want to echo the comments of Senator Carroll. I appreciate you tightening this up a little bit. I will say in the past, one of these definitions, I know the prosecutors had concerns with. It's still in there. They're not here today to express any concerns, so that goes a long way to me that no one's here in opposition, so I'm for it. Thank you.
Thank you.
President Stivers, Senator Turner, Senator West, Senator Wheeler, Chairman Westerfield.
Aye. Bill passes with favorable expression. Yes, sir. Yes, you can.
I'd like to change my vote from no to yes.
Okay. That means 9. 9-0. Motion made and seconded. Thank you. All those in favor, please vote by saying aye. Aye. Those opposed? There you go. Thank you, Representative.
Thank you all.
Must
Thank
be
you,
my Sheila. lucky day. Thank you.
Nice. Well played. All right, before everybody runs out the door, anybody need to record any votes other than me? All right, I'm going to record an aye vote on everything else. 245, 378, 256, 269. Sorry, just did that. 310, 458, 501, and 590. I was later. All right, seeing no further business come before the committee.